every parent of a child with SEND needs to understand the reduction to legal rights buried in the resolution and legal framework section of the SEND reform proposals. This section fundamentally changes what families can appeal, how disputes are resolved, and how much of the future system would rely on schools and local authorities doing their best rather than having legal duties. Please bear with me because the information throughout this video is absolutely vital, not just for families, but for educators too, because it will increase pressure on school staff. If your only exposure to this document is through the consultation questions, you won't have seen this section because there aren't any questions on it, and that's very important, and we will come back to that later. They start by saying they'll improve complaints and mediation processes so disagreements are resolved faster, and collaboratively they'll reduce the need for an appeal to the SEND tribunal, but it says families will retain the right of appeal to the tribunal. They move on to talk about resolving concerns on the universal offer and targeted layer of support, which will be dealt with by schools and colleges' complaints processes, including a new digital solution for handling complaints. They say all schools are required to have a complaint procedure, and in a complaint relating to SEND provision or support, that complaint should be considered by a panel, including a SEND specialist, like a SENCO, an inclusion lead, or senior school leader with SEND experience who is independent of the school. I do wonder if SENCOs and inclusion leads feel equipped to make such significant decisions, really. Then they move on to resolving concerns about specialist provision, but notice the complete absence of the targeted plus layer from these plans. That is where most disputes are going to occur, because those are the children deemed to need significant support, but not enough support to warrant a specialist provision package and an EHCP. They say for specialist provision, they will seek to strengthen local authority commissioned independent mediation services. Parents will not have to take part, but they will need to consider it before appealing to the tribunal, which is the case now in most situations. If this doesn't resolve things, they say parents will be able to appeal to the tribunal for a ruling in the same way as happens now. But it's not the same way as happens now. Honestly, this infographic is one of the most important pages in the whole document because it really lays bare just how fundamentally appeal rights are changing. The focus of tribunals now are what does this individual child need on a very specific level. But under the proposed system, appeals would shift to whether the correct package has been applied or whether the process has been followed correctly. That is a completely different type of appeal than we have now, because instead of arguing this child needs different support and I can prove it, families can only argue you haven't applied the right framework or you haven't followed the right procedure. And if the framework itself or the package is unsuitable for that child, that becomes much harder to challenge. The infographic also shows how tribunal powers are reduced as they can no longer name a setting. Decisions will be tied to these predefined packages of provision. It does say you can still appeal to tribunal about disability discrimination cases, including whether reasonable adjustments should have been made. It feels as though many appeals to tribunal could shift from the current appeal basis to disability discrimination claims. So whether we'll see a reduction in appeals or whether people will just pursue disability discrimination instead, we'll see. They repeatedly say through this document that families should not need to go to tribunal, and I agree. Like every other parent who has ever had to go to tribunal, nobody wants to face a local authority funded barrister in court just to get the support their child needs and is legally entitled to. But the solution to reducing tribunals should be fixing the problems that force families there in the first place, not reducing what families can appeal or weakening independent oversight and resolution. Because if the new system genuinely works as promised, if children are supported earlier, if schools are properly resourced and children's needs are genuinely met, then tribunal numbers would fall anyway, just as EHCP numbers would fall if the support is provided without one. Despite how significant these changes are, and they really are, there is not a single direct question asking families whether they agree with reducing tribunal powers or fundamentally changing the basis of appeals. This is being challenged via judicial review on the consultation, and the government initially responded to that, saying that they deliberately did not ask questions on this because they'd already decided these changes would be made. They've now changed tack and said they do want your views on all aspects of the reform, so that's why we are looking at it here. The only actual question for this whole section is whether SENCOs should sit on school complaints panels, which honestly is extraordinary given what's in here. Yes, SENCO should absolutely be there. They should be part of the senior leadership team. They should be properly resourced, professionals with dedicated time and expertise to doing their job. If complaints panels are going to make decisions about SEND provision, they really need input from skilled professionals like educational psychologists, speech and language therapists, occupational therapists, and anyone else required. Because many of these disputes will require expertise that school staff do not have, and I'm sure they'd be the first to say so. And this is just another pressure on educators in a long list of them that I don't think they can bear. So for question 38, I think SEND expertise on complaints panels would definitely help. But complaint systems are not a substitute for genuinely independent appeal rights, and families must still be able to challenge decisions effectively outside the system that is making them. And that's before we get to the fact that children in the targeted plus layer are just completely absent from these plans, which is a shocking oversight. It's incredibly misleading, in my opinion, to tell parents they are retaining the right of appeal to tribunal, because rights can technically remain on paper but function very differently in practice. If you want to watch the rest of my videos, there's a link to a YouTube playlist in my bio that takes you through them in order while you're going through the form.